What happens in a criminal case when you're not mentally competent to stand trial? My name is Carl Birkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I want to take a couple minutes to help you make law easy and talking just a little bit about when and how your mental health can play into a criminal case, especially in instances where it prevents you from actually being able to assist in your defense and stand trial. So I've been doing this for a little while, and I've had a couple of times where uh, my client's mental competency has been a factor in trying to figure out what to do with their criminal cases. So in these situations, what you want to look at is, do you think that they have capacity to make their own decisions and to ultimately assist in their defense? Usually attorneys can figure that out by having one or two conversations with their client. Um, if I'm asking my client questions and he's not able to answer them, or if I'm asking my client questions, and okay, when I say not able to answer them, I don't expect my client to have knowledge the same level as an attorney. But if I'm asking him what day it is and they say the color's purple, then I'm going to have some questions about if they truly understand what we're talking about. Those are the types of things that really lead me towards thinking that I might need to question their competency. Uh, a lot of times, I'm not the first one to have these questions. Usually, if this is an issue, friends and family of the client will also kind of come to me and just say, listen, this is something you need to know. This is something they've been dealing with. Maybe it's a medical diagnosis. Maybe it's something where there's some learning disabilities involved. Maybe there's a case of head trauma or brain injury or something like that. Those are all justifiable things that would prevent someone from being able to assist in their trial or prevent them from being considered to be competent, at least in a legal sense. So what we do is we'd file a motion to determine competency. We'd have a hearing set for it. The court would order a competency evaluation to be done. If my client's sitting in custody, then that's going to kind of trigger a waiting game to see when the state's going to be able to perform that evaluation. After the evaluation's done, if there's a determination that my client's incompetent, we'll have another hearing on it. We'll present the findings of the evaluation. The defendant actually will have, at that time, an opportunity to object to the findings. And if they do, then you have to have a full-on, evidentiary hearing about it. But if the defendant doesn't object to the findings and essentially allows themselves to be deemed incompetent for the purposes of their case, then it comes down to when and how can we get them treated so that they can stand trial. The goal is never to just leave someone incarcerated, deemed incompetent, and just sitting there forever. The goal is always to get them back up to just at least a level of competency to where they can help with their case. This isn't always quick. Sometimes I've seen cases where it happens in a couple of months. I've seen cases where it takes upwards of a year for that to happen. It really just kind of depends on the situation. It's a really heavy thing to have to deal with. And if you or someone you know is in that situation, my heart goes out to you. If you have questions about it or you think you might need the assistance of an attorney on this, absolutely, please reach out to our office. My name is Carl Birkhead. I'm with Worth Law Office, and I want to help you make law easy. Thank you.